So it's important to understand when the judge is sitting in law and when the judge is sitting in equity. The judges in the United States wear both equity and law hats. In law, as we've just learned, it's possible to win a jury trial. In equity, it is not. So we need to know when is the court and the judge sitting in law and equity, and basically it derives back to the old English law. Requesting money damages and legal remedies such as replevin and ejectment, these were all legal remedies, and the judge in those situations is sitting in law. So we look back to the history and see where the case would have been taken in England several hundred years ago. Would it have been taken to the law courts, or would it have been taken to the separate equity courts, the courts of chancery? There is no right to a jury trial when the court is asked to decide equitable matters. These include injunctions, restitution for unjust enrichment, quasi-contract, and other equitable decrees that would traditionally have been taken to the court of chancery and not available at the court of law. So, how do we decide cases involving both legal and equitable issues? Well, in the federal courts, the judge decides the equity claims first, then the jury decides the legal claims. The jury is prevented from looking at the equitable issues through res judicata. In the state courts, they have an equitable cleanup doctrine. The judge basically mops up the legal claims when deciding the equitable matters. This takes place when the case is primarily in equity. Some states, however, follow the federal courts and use a jury to decide the legal matters and the judge to decide the equitable matters. Under the US Constitution, the 7th Amendment, there's a right to a jury trial for cases where the controversy is in excess of $20. This applies to legal cases in federal courts. It does not apply to state courts, and it does not apply to cases in equity, which can be decided by a judge alone. However, many states have mirrored the 7th Amendment in their own constitutions, and they do provide voluntarily a right to a jury in legal cases. There are complications, as we'll see later, when legal and equity claims are combined in the same case.